I'm Drew Stevenson, and this is a lecture for my administrative law class about the case Safe Extensions Incorporated versus the FAA, or Federal Aviation Administration. This is a DC Circuit Court of Appeals case from 2007 about courts reviewing factual findings when the substantial evidence test does not apply. And just to put this in context of our course for my students, we're studying this after the line of cases like Hearst and Universal Camera that are about the substantial evidence test and how judicial review works regarding agency findings of fact. This case on the surface seems kind of easy, right? Because it's not a true substantial evidence case because there's no formal adjudication by the agency. There's no decision on the record. But the court ends up finding a way to work a substantial evidence review into arbitrary and capricious review as sort of a component of that. And that's what makes the case both confusing and interesting. So let's look at what happened in safe extensions. So let's start with the statute, like we always do in administrative law. The statute and the agency really matter, sometimes more than the facts themselves. So we have some federal statutes or federal law that charge the Federal Aviation Administration, or FAA, with promulgating safety standards for commercial airports. And that's what this case is about. The FAA usually does this by issuing advisory circulars that set forth testing requirements and product specs for airport equipment and fixtures. So anything, all of the equipment that you see them using, the different types of lights and signage and so forth. And then testing requirements basically end up going to private labs. So private labs do testing on the products to determine whether they comply with FAA standards, and then the FAA publishes a list of approved items. In other words, if you're a company, then you get your product tested by a private lab. The lab gives you their test results and certifies them, and that goes to the FAA. And if your stuff passed the test, then they will put your products on an approved list. So airports that receive federal funding, which is basically every public use airport, not private airstrips, but anywhere where you might be buying a ticket to go on a flight, even a chartered flight or something like that, are prohibited from using unapproved equipment or products. And this includes the runway lights and the metal bases that hold them. And this case is specifically about the recessed lights. And so I don't know if you can see it in the picture that I have here. There's lights on little stands that run along the sides of the runways. And then there's lights that are sort of flush with the runway that the plane actually runs over as it lands. And because the planes run over them, and also because in areas where it snows, snow plows have to clear the runways. These lights have to withstand a lot of pressure or weight. And so there's two types of these sort of recessed runway lights. One is called adjustable, and those are made by Safe Extensions and some other companies. And then some of the competitors in the industry make another type that are called fixed. And it doesn't matter for our purposes here what the difference is. Just trust me that one is called adjustable and the other type is called fixed. And for many years, airports could really use either. And they both types had to pass a torque test in order to be approved for use in airports pursuant to these FAA circulars. But in 2005, the FAA issued Advisory Circular 42D, and that's when the problem started, which said that torque testing from then on would only be required for bases, the quote, that utilize a method of height adjustment that is integral to the base or extension and are designed for field adjustment. That's basically a fancy way of saying these adjustable bases for these runway lights. Now, it's really seemed to everybody who read this that the FAA meant that this would only apply to the adjustable products and not fixed products, and that only the adjustable ones had to pass the test. So even though the torque test is under this circular was the same that they'd always had to pass, now basically the some of them don't even have to do the torque test. They can just sell direct. They're automatically on the approved list, the fixed ones. And then now only the adjustable products had to pass it. And those are the ones made by Safe Extensions Incorporated and a few other companies. And so imagine that we decided that half of your administrative law class actually didn't have to take the final, and but the other does, right? And so that's what's a rough analogy to what's happening here is that some companies that make their living selling equipment like lights to airports for runway lights have to go and get this sort of expensive and time-consuming torque testing done, and some of their competitors can just skip that step. So it gets worse. About a year later, the FAA followed this with another advisory circular with more stringent testing requirements that the adjustable bases would never be able to test. In other words, they had to pass a torque test under different circumstances than they were used to, and the nature of these adjustable fixtures was such that there was no way that they could pass this torque test. They said. So that basically meant that Safe Extensions and others would just not be able to sell their products to airports anymore, and would basically have to find other ways to make money or go out of business. So there was a lot of complaints from the regulated industry about this. So it's not just one company that seemed to be felt targeted here. There were a few others along with Safe Extensions. And in these kind of conversations and phone calls and things like that, the FAA administrators indicated that they would go ahead and revise the circular when they got a lot of heat for it. But then they drafted a revision and only shared that with a few company reps, not Safe Extensions, but they picked a few people, showed them what they were thinking of doing, and those people said, you can't do that. They objected to it because they said it was basically just as bad as the last circular, which if you've been paying attention to this video, we have two circulars, one that said only this one type of runway light has to pass a torque test. And then the second one says, and now you have to pass an impossible torque test. And now we're revising the second one, but not really revising it. So the revised circular then gets issued to the industry without changing the points of concern. And in fact, it actually then had a section that addressed the objections that they had received from a few people and explained why these didn't matter. But I want you to see that they're kind of calling this public comment, but it's not. It's private comment. They hand-picked people, and then they're sort of debunking their comments, but the Safe Extensions didn't really have an opportunity to participate in any type of comment period or hire their experts to explain why the agency was being unreasonable. Now, the FAA had a lot of arguments here. And by the way, if you read this opinion, you can tell that the DC Circuit is really exasperated with the agency and uses kind of caustic language with them. And so, but one of their arguments was that there wasn't any real factual record like you would normally have for a regulation. So therefore, there should be no judicial review. In other words, the FAA was saying, we didn't have to do notice and comment rulemaking, and they didn't think that they should even be in court. They were basically challenging the jurisdiction of the court or the idea of having judicial review for any of these circulars because they said, we don't really develop a record that the court could review. How do you think that's going to fly with the court, right? That basically saying, you know what, we don't show our work here, so you're out of luck in terms of evaluating what we've done. And in fact, as the DC Circuit notes in this case, the Supreme Court had really rejected this notion already in some prior cases. And instead, basically, the way things stood was that an inadequate record should actually force a court to just remand to the agency so the agency can provide a record for review. In other words, the FAA is saying we don't have any like files showing that we studied facts or did tests or anything before we issued this circular, so I guess we're off the hook. And that's not the way the line of cases really should read. It seems more, at least according to the court here, that if the agency hasn't really created a record of a decision they're making, then we should just remand and make them do it before this circular can go into effect. At the same time, the court here says that even if it accepted the agency's argument about a factual record being a prerequisite for judicial review, it says there's actually enough of a record here. So the agency is trying to say there's no record for you to review, and therefore you can't give judicial review. And the court is saying, so first of all, we could reverse you just for that. But the fact is, we actually do think that there's some facts here, and the facts don't support your case at all. They basically said that there's a thin, but still some factual record here, and it doesn't support the agency's position as being reasonable. And after addressing some other issues, the court then announces that they're going to apply the arbitrary and capricious test or review to the merits of the case. And that's when the case takes a weird turn, to be honest. The court then sort of merges arbitrary and capricious review with substantial evidence review. Hopefully you've really looked at the section 701 to 706 of the Administrative Procedure Act at least once, and know that there's a list of different standards of review or scope of review, some courts call it. And so they say, and this part is true, that this is an informal adjudication under the APA. This, by the way, is what makes this case a little different from some of our cases where we look at an agency is trying to say that their rule is just a policy statement or a guidance document or an interpretive rule. And they're basically trying to say that it's kind of like not right rulemaking. And the court here basically says that this is informal adjudication, which under the APA is everything that an agency decides or decision they make that's not formal or informal rulemaking or formal adjudication. And so every other decision by an agency, according to technically under the APA, is informal adjudication. Here's a couple of quotes from the court. The agency's decision still must be supported by substantial evidence. Otherwise, it would be arbitrary and capricious, for it is impossible to conceive of a non-arbitrary factual judgment supported only by evidence that is not substantial in the APA sense. Now, if you're not catching what the problem is here or why this is significant or confusing, it's because in the APA, when it describes the substantial evidence test or review, that is only for formal adjudication, formal rulemaking, or decisions that have to be decided on the record, that it actually uses those phrases. And so those would be under APA, or it mentions sections, the APA sections 554 to 557, and which are basically formal proceedings. And so it wouldn't normally apply to informal adjudication. And so the court here is saying that arbitrary and capricious also includes a substantial evidence component. And I think that's novel a little bit. By the way, I pulled out a quote that I liked for you, for those of you who kind of like to highlight things in your cases. The difference between this informal adjudication and a formal adjudication on the record, which hopefully you're tracking with me here, is not the amount of evidence the agency must provide to support its decision, but where the evidence may be found. In an adjudication on the record, substantial evidence must be found within the record of closed record proceedings. While in an informal adjudication, the agency can provide the court with evidence it had before it, when it made its decision. Now, if you aren't really tracking with the significance of this quote, you might want to pause the video and read this again very slowly, and kind of reference the standards of review in your casebook to see what the court is doing. It's basically saying there's no difference in the quantum of proof or evidence that an agency has under these different standards. The question is whether we have kind of a closed record proceedings like you would have in a regular trial almost, or whether it could be open-ended, right? Everything like meeting minutes and notices and emails and studies that the agency collected and things like that it had before it when it made its decision. That's an open record. And in that sense, now this is actually starting to feel a little bit more like the Overton Park case, to be perfectly honest. Okay, so wrapping up here, the FAA basically failed to provide evidence of previous problems in the field with these adjustable runway lights. And so it, quote, failed to provide substantial evidence to support this rationale. And because there was a lack of support in the evidence that the agency considered in its decision, the court found it arbitrary and capricious and explained that an agency decision unsupported by substantial evidence is also, therefore, arbitrary and capricious. Okay, that concludes our lecture about Safe Extensions Incorporated versus FAA.